Mr. Murali.
Mr. Deputy Speaker, I declare my interest as a practicing lawyer. The Legal Profession Amendment Bill introduces various amendments to the Legal Profession Act. The introduction of a further disciplinary option that can be imposed against an errant legal practitioner and the creation of the unclaimed money funds are noteworthy innovations that should be welcomed by members of this House. I wish to make 3 short points on the proposed amendments. First, Clause 17 of the bill proposes to amend Section 50 of the Act to allow for the penalty paid by any lawyer for failing to vote in council elections to be paid to the Law Society and not the compensation fund. The compensation fund is a fund administered by the Council of the Law Society to serve a public purpose, in that grants may be paid out of the fund to mitigate loss suffered by any person due to dishonesty of a lawyer or a member of his staff. A similar amendment was made in 2001 for penalties paid as a result of disciplinary proceedings to be paid to the society instead of the consolidated fund, so that the Law Society could use the monies for worthy causes, such as providing pro bono services or creating legal awareness. In these circumstances, what is the purpose behind the change? And will the monies directed to the society will be also used for similar worthy causes to serve public interests? What would be the consequent effect on the compensation fund in terms of its funding level if the monies were to be channeled to the society? Would the fund have sufficient funds to meet claims from members of public? Also, given that the Law Society has just moved to e-voting recently, what is the expected amount of revenue generated for use by the society from penalties for failing to vote? Second, the bill introduces the establishment of a new unclaimed money fund to allow for the transfer of unclaimed client or intervention monies to be paid into the fund and to vest in the Law Society absolutely. At the same time, it does not appear that the proposed amendments require the Law Society to take reasonable efforts to return the monies to the owners. In this regard, I note that the Honourable Senior Minister of State stated that the Law Society will require solicitors to expend reasonable efforts before they are being allowed to transfer those monies to the Law Society. But vis-a-vis the Law Society itself, it's not clear what steps the Law Society would have to undertake and who checks on the Law Society in relation to the steps the Law Society would have to undertake to locate these claimants or potential claimants. In the context of government agencies, the Ministry of Finance had made a statement that all government agencies, including state boards, are required to make all reasonable efforts to return unclaimed monies to the rightful owners promptly. This being the case, what can be done to ensure that the Law Society expends sufficient efforts to contact the rightful owners of these monies before it decides to use these monies for pro bono services? Finally, the proposed amendments to the Act expands the range of measures that may be imposed by the Inquiry Committee, the Council, and the Disciplinary Tribunal to include remedial measures to be taken by the legal practitioner. Given the breadth of professional conduct rules legal practitioners are bound by, could the Honourable Senior Minister of State please clarify what kind of remedial measures are contemplated and in what situations would remedial measures be imposed? I believe the Honourable Member, Mr. Christopher D'Souza, made a similar request. In this regard, I wonder if there's any reason for the proposed amendments not to provide for the Court of 3 judges, which sit at the apex of the disciplinary process, to also impose remedial measures. Would the Honourable Senior Minister of State accept that the absence of the empowering provision does not curtail the powers of the Court of 3 judges to impose requirements on legal practitioners, such as undertakings to the court, which may mirror obligations imposed through the remedial measures? Notwithstanding the clarificatory points I've raised, I support the bill.